In this video, we're going to take a look at the Renters Reform Bill as it currently stands in the summer of 2023. First of all, let's have a look at what's happened so far. It was back in 2019 in the Conservative government's manifesto that many of the key aspects of the Renters Reform Bill were first outlined. The Renters Reform Bill was mentioned in of itself at the Queen's speech on the 19th of December later that year. The bill then stalled somewhat for a couple of years, primarily because of the global response to the COVID pandemic. And more recently, we have seen the war in Ukraine and the energy and cost of living crisis, and therefore this has delayed the bill being put to Parliament. In June of last year, so 2022, a white paper was published, and this set out a 12-point plan of the key areas that would be covered in the proposed Renters Reform Bill. So this gave us a little bit more indication of what to expect. It's only been in May of this year that the Renters Reform Bill has been put before the House of Commons. So on the 17th of May, it had its first reading in the House of Commons. Now, usually the second reading takes place fairly quickly thereafter. However, it has now been announced that the second reading will now not happen until after the summer recess. So this is the 3rd of September onwards. In the UK, Parliament essentially closes for the month of August, and so parliamentary business does not take place during this time. I think it's interesting to see that things have been going on in the background that you might not be aware of. There is a website, parliamentlive.tv, which essentially live streams various different committee meetings or evidence hearings in relation to government business, and this is in the public domain and free to watch. And you will see here we have got a very short clip from the Levelling Up Housing and Communities Committee, which has been debating the Renters Reform Bill. Now I'll just show you a very brief clip of this because it's not the most interesting thing you've ever seen in the world, but it gives you an idea of the sorts of people who are at the meeting. You'll see here it's got at various different timestamps in the video the various different people at the meeting and who they are representing.
The Levelling Up Housing and Communities Select Committee. It's a further evidence session we've got this afternoon in the reform of the private rent sector. Since we last had our evidence sessions, the government has moved on somewhat and produced a bill now for us to have a further idea about what their intentions are following on the white paper from last year. So we've got two sessions this afternoon. Before I come on and introduce, or ask themselves to introduce the first panel, and then following that the Minister, I'll ask members of the association. Okay, not to okay.
I employ a councillor.
I'm Vice President of the Local Government Association. I employ councillors in my office. I'm also a private sector landlord.
The same, but I'm not a landlord. Right. Andrew.
I'm the Vice President of the Local Government Association, and I'm Chairman of the All-Party Parliamentary Group for the Private Rented Sector, for which the National Residential Landlords Association provides the Secretariat.
Okay. Thank you for that. Thank you to our witnesses for coming this afternoon to give evidence to us. Could I just go down the table and ask you to introduce yourselves and just say who you're representing?
Okay, it's Richard Baker. I'm the Housing Ombudsman at the Housing Ombudsman Service.
Darren Bacter, Policy Manager at Shelter.
Ben Beadle, Chief Executive of the National Residential Landlords Association.
So you can see here that's just quite a very short snippet just to show you some of the key players that were at this meeting on the 10th of July. There'll be more of these evidence hearings as the bill progresses through Parliament, and as I say, all of this information is in the public domain and you can go and check out parliamentlive.tv for yourself. They also have a library of historical videos that you can go back and watch on all the different topics that have been debated. Okay, so just in terms of timeline, let's have a look at where we're at. So I've taken this from the government website. And this sets out the timeline and the steps as to how the bill gets from its current stage all the way through to being passed as an Act of Parliament. So we can still see here that the bill in this case has started in the House of Commons and had its first reading in May. As we've said, the second reading is now delayed until after the summer recess, and I think we are waiting on a date as to when that will take place. We can see then there are all the stages that the bill must go through. So the first reading is just, the bill is just announced in the Houses of Parliament. At the second reading and the committee stage, then people can get involved in a debate and a discussion, can suggest amendments or seek clarifications, and various different representatives external to Parliament, as we saw on that video there, can put evidence into the debate. So we've got the second reading, committee stage, report stage, and the third reading yet to go in the House of Commons. Once the bill has gone through all of those steps, it then essentially has to go through those mirror steps again in the House of Lords. So you'll see in the House of Lords there is still first reading, second reading, committee stage, report stage, third reading. And the House of Lords can then also seek to make amendments as it goes through the process in the House of Lords. The final stage is that if the House of Lords does make further amendments or suggestions, the bill then has to go back to the House of Commons, and essentially the two Houses of Parliament need to then agree on all of the suggested amendments before the bill can get royal assent. So this can be a little bit tricky if there are various areas of contention, and I'm not just talking about this bill, but any bills that go through Parliament do need to be agreed by both houses. Once that agreement has been reached, then royal assent will be given. So essentially this is a formality, and the King essentially gives his seal of approval, and the bill becomes legislation and becomes an Act of Parliament. Now, what we do know, given that the second reading in the House of Commons, which is only the second step, has been delayed until after recess, royal assent now cannot be received during this Parliament. So Michael Gove, who is the leading MP on this bill, had announced that he hoped this would get through all stages of Parliament before this Christmas. This is now not going to happen, given the timescales and the steps that the bill needs to go through. What we do know already is that once the bill receives royal assent, then the law does not become into force until 6 months after that period. So sometimes a bill can get royal assent and becomes law at midnight that day. In other cases, there is a delay, or there is further legislation that needs to be put in place to make that law become active. What we also know from the information that's already been published is that there will be two stages of the implementation of this Renters Reform Act, I guess, as it will become. It's currently a bill, it will become an act, and some clauses affecting existing tenancies will not come into force until 12 months after that first implementation date, which, as I say, will be 6 months after royal assent. So essentially, once royal assent has been received, there will be some clauses in the Act that will not become law until 18 months thereafter. Now, when you work that through in terms of the calendar, that means that this implementation date affecting existing tenancies is now highly unlikely to happen before autumn 2025, and I have seen some commentators suggesting it may be 2026 before this law fully comes into force. I thought it was useful just to highlight the Renters Reform Bill is not just an act of Parliament in its own right. Actually, what it does is it proposes amendments to various other pieces of legislation which are still in existence. The main one is the Housing Act 1998. So this is the one that is going to have the most significant amendments to it. But in putting forward the key aspects of the Renters Reform Bill in order to bring them into law, then these other pieces of legislation also need to be amended. So again, you can see this is where the law is not simple and where it is important to know the consequences of some of these changes, and if you need to seek specialist legal advice. Having read the Renters Reform Bill myself, I was also really taken aback by the amount of other related legislation that is mentioned in the bill. So you can see here is a list of all the other pieces of legislation mentioned in the Renters Reform Bill. Now these Acts of Parliament are not necessarily going to be amended by the Renters Reform Bill. However, they contain in them usually some sort of definition which the Renters Reform Bill is relying on when it is making significant amendments to the Housing Act 1998. I thought it might be of interest for you to see an extract of the Renters Reform Bill. This is literally a screenshot of one of the pages which talks about the statutory procedure for increases of rent. You will see that this page in of itself does not really make much sense. You can't read the Renters Reform Bill on its own as a standalone document. As you can see on the screen here, essentially what the Renters Reform Bill is doing, as I mentioned with the list of legislation being amended, is it is simply amending existing legislation. So we can see on the first line here, it says Section 13 of the 1998 Act, and that refers to the Housing Act, is amended in accordance with subsections 2 to 8 below. And essentially, particularly in Section 4 there, you can see it's literally just an instruction of how to amend the 1998 Act. So you have to go to the 1998 Act and look at subsection 2, paragraph A, and read that in its entirety, and then substitute the words that are set out here. So I just thought that would be a point of interest so that you can see how the legislative process in the UK works. It's really quite interesting, but also means that it is really quite complex and is not necessarily easily accessible for most people. So to read this, you do need the Renters Reform Bill and those other acts that are being amended side by side so that you can get an overview of what's happening and what the proposed changes are. Now, obviously, I don't expect you to do that, and I have done that for you, and that's the whole point of today's presentation. So what I'm going to do is I'm going to run through the key impacts or the key changes that the Renters Reform Bill is proposing and putting forwards. Now, I'm not going to go through every single clause or every single aspect of the Renters Reform Bill because it does get a little bit detailed and quite technical in places, but these are the headline aspects that you as property investors and landlords really do need to know about and be prepared for. The biggest change the Renters Reform Bill will bring in is the end of fixed term tenancies. Common practice in the private rented sector at the moment is that a tenant will agree to a minimum of a 6-month fixed term contract under an assured short hold tenancy or an AST. Some people use 12-month fixed term tenancies. You can actually fix terms for up to about 3 years if you so wish to do so. What the Renters Reform Bill will, as it says on the slide here, completely abolish assured short hold tenancies. So a whole chapter of the Housing Act will essentially be abolished in its entirety. What that means is that from day one, all tenancies will be periodic with no end date. And under the bill, tenancies are to be periodic, with the rent period not exceeding 1 month. So again, under this bill, you can't have 6, 12, 18 month, 3 year tenancy terms. The tenancies will be periodic from day one, and the rent is due not exceeding 1 month. Now, it does sound as though you can have a tenancy shorter than that. So for example, if you wanted to collect rent on a fortnightly basis, the periodic tenancy would then become fortnightly. So the periodic tenancy matches the time at which the rent is due. There is also a specific clause in the Renters Reform Bill that says fixed terms will no longer be recognised under law. So not only are they abolishing this, but there is a clause in there which essentially says that if there is a fixed term contract out there, it cannot be relied upon under law going forwards. The next biggest area of change is under Section 8 grounds. So Section 8 relates to Section 8 of the 1988 Housing Act, and this clause in the Act sets out the grounds under which a landlord can regain possession of their property and the grounds on which that they can ask a tenant to leave. Under current legislation, these grounds are split into mandatory and discretionary aspects. Under a mandatory ground, the court has to find in the landlord's favour and the tenant has to leave. A discretionary ground is just that. The court can look at both aspects of the case from both parties and can use its discretion as to whether to ask the tenant to leave and within what timescale. Now, the mandatory and discretionary aspects will remain going forwards, but there are some new grounds that will come into play under the Renters Reform Bill. The first one is to sell the property. So currently there is a ground in there where the mortgage company can regain possession of the property if, for example, the landlord defaults on their property. Going forwards, the landlord will be able to ask the tenants to leave if they want to sell their property. Now, I have read some additional information. This isn't in the bill, but it sounds as though additional evidence may be needed to be provided. For example, a letter from a solicitor confirming intent to sell the property. So it can't be relied upon by a landlord who just says, oh, I'm selling, here's your notice. So there is some protection in there to protect tenants from potentially unscrupulous landlords. There's going to be a new ground of serious rent arrears. So at the moment, there is a mandatory ground for possession of the property where the tenant is 2 months or more in arrears. And there's also a discretionary ground for late payment of rent. But this new ground is much more serious rent arrears, so where to prevent the tenant from essentially gaming the system. So if they have been in serious rent arrears, so this is 2 months, more than 3 times in a couple of years, then that is seen as a pattern and will be a ground for repossession. The grounds going forwards under the Renters Reform Bill are also then split out between grounds relating to a tenant and grounds relating to a landlord. So one of the new grounds relating to the landlord is to ensure compliance with an enforcement action. So for example, if a landlord has a banning order against them. There are other new grounds proposed around agricultural work. So this is to encourage seasonal agricultural workers to come and assist with the economy, and where people's employment criteria changes. So for example, if they are provided accommodation with their workplace, there will be new rules around that. There's also some new grounds around supported accommodation and homelessness duty. For example, if a property had previously been used as supported accommodation but isn't currently, and there is a plan to revert it back to supported accommodation, then that is an allowable ground to ask the current tenants to leave in order to return the property back to supported accommodation. In addition, there are numerous changes to existing grounds for requesting your property back. There will be reduced notice periods for antisocial behaviour. So this is a concern, particularly a concern I have. We don't use Section 21 notices very often, and we don't use them lightly. However, in my experience, they tend to be used for a combination of rent arrears and antisocial behaviour that hasn't reached a criminal level. There will be definitions of what antisocial behaviour will be in these grounds going forwards, and hopefully the law will be strengthened so that tenants, particularly I would suggest in HMOs, where you have an antisocial tenant, can be dealt with promptly so that it doesn't affect the whole household. And obviously in single lets as well, you need to be mindful of the neighbours and the local community. Currently, there is a ground under Section 8 where if you as the property owner want to move back into your property, you can ask the tenant to leave. That will be extended to also include close family members, not just the landlord. Again, there is some discussion around evidencing this so that you can't just rely on your say-so that this is what's going to happen, and that's why you are asking the tenants to leave. Now, we mentioned earlier fixed term ASTs, fixed term contracts are going away completely. Every tenancy will be periodic from day one, and this is causing a lot of problems for the student market. So in the student market, tenancy agreements tend to be 9 to 12 months long. So potentially some people might offer a 9-month let, and therefore the students are not there in summer, or they might offer a full 12-month tenancy, but there is a mechanism currently under current legislation to ask the students to leave so that the new cohort of students can all move in time for the new academic year. With the end of fixed term tenancies, there are various people in the student sector who are worried that some tenants might not leave at the end of the 12-month period, and therefore this would disrupt the academic year cycle of a group of new tenants moving into the property each year. There's a lot of lobbying and discussion going on in that area, and it could very well be that the student population is exempted from that, or there are slightly different rules that might be developed for student lets. Currently, there is a ground that a property can be repossessed from the current tenant if you are having a minister of religion moving into that property. However, you currently have to tell the tenant before they move in that you might want the property back at some point in the future for this reason. That prior notice for this particular ground will go away. So there will be no requirement for you to notify tenants up front. On redevelopment of a refurbishment, so there is currently a ground where you can ask a tenant to leave if redevelopment or refurbishment of a property will be so extensive that it's not suitable for somebody to live in that environment during the period of the works. Going forwards, this redevelopment or refurbishment ground will only be allowed after 6 months from the start of a new tenancy. Death of a tenant ground is going to be extended, so you will then have 24 months rather than the current 12 to start possession proceedings. So this is to allow additional time for complex probate cases, for example. And I did mention there is a current ground under Section 8 for rent arrears. There will be an exception where somebody has fallen into arrears because of delays in universal credit payments. Again, universal credit payments towards the rent is a whole topic area in its own right, is very complex and fraught with difficulty. And can cause tenants who, for example, change jobs or get a job, or their circumstances change and therefore their benefits change, can fall into difficulty with paying their rent. The bill talks about rent increases. There is a mechanism to increase rent at the moment, and the Renters Reform Bill clarifies that going forward, Section 13 of the Housing Act 1988 will still apply. What this says is that rent can only be increased on an annual basis. At the moment, rent can be increased in line with a contract or in agreement with the tenant. Going forward, the notice for any rent increase will be 2 months, so you'll have to give your tenants 2 full payment cycles of notice for any rent increase. The tenant will be able to apply to a tribunal to challenge the rent increase. This isn't really a change from now. The tenant still can go to first tier tribunal if they wish to challenge the rent increase. However, the way the tribunal looks at a challenge does look to be a little bit different. The indications I have seen show that consideration will be made of the market rent, not just whether the increase is reasonable or not, and will take a broader view, and the tribunal can determine the rent and the date that any new rent is payable from. So that's not completely different from what we currently have now, but does put some clarification in place for how rent increases will need to be handled going forwards. Pets have also hit the headlines as well. Now this does exclude social housing, so this is only really for the private rented sector. The tenants will have a right to request a pet. Now for us in particular, this isn't really an issue. We have many of our tenants have pets. Particularly cats and dogs seem to be the ones that are catching the headlines. A lot of people saying that they are unable to move because their landlord will not accept cats or dogs. Now, having had both a cat and a dog myself personally in the past, I do know that they can cause damage to the property, and under the Tenant Fee Act 2019, landlords were prevented from asking for an extra deposit for pets or any other sort of financial cover from the tenants to potentially cover the cost of any damage caused by the pets. Going forwards, the tenants will be able to request a pet, but this must be in writing and include a description of the pet and submitted to the landlord. The landlord does need to agree in principle, so the default position is the landlord has to agree and cannot unreasonably refuse a request. However, the request for a pet can be refused if this would be in breach of an agreement with a superior landlord. Let's say, for example, you have an apartment in a block of flats and therefore you have a superior landlord, so the leaseholder or the freehold owner of the block of flats, and you have a lease with them. It's very typical in those documents that pets are not allowed in those sorts of properties. So if you then rent that flat out to a tenant, the requirement from the superior landlord not to have a pet flows all the way down to the person going to be living in that property, and in that case you therefore have a valid reason to refuse the tenant having a pet. What the Renters Reform Bill will do to help encourage landlords, though, is will amend the Tenant Fee Act. So you remember earlier there was a big long list of legislation that will be impacted. The Tenant Fee Act of 2019 will be impacted, so that you will be able to ask the tenant to take out pet insurance as a condition of taking the property. At the moment, you're not allowed to ask the tenant to undertake any more financial commitments in order to take a property. But under the bill, you will be able to ask them to take out pet insurance to cover the cost of damage, or if you already have, for example, you've got buildings insurance on the property and you speak to your insurer, you can, if they offer this service, you would be able to pay an additional premium to cover damage by pets, and then you would be allowed to recharge that additional premium to the tenant. So in this way, it's looking to strengthen the tenant's requests for pets, but also to protect the landlord from excessive damage costs. Just a few other things that don't really fit under any of the other headings but are quite interesting, and I just wanted to point out. So where you've regained possession through a Section 8 notice, and so ground 1 or 1A is essentially you are asking for the property back so you or a close family member can move into it. What they are suggesting under this bill is that you would not be able to re-rent that property out to another tenant for a period of at least 3 months. Again, this is try to protect against unscrupulous landlords who do move back into their property, but move back in for a week or two and then re-let it, and use that as a reason to ask their previous tenants to vacate the property. So there will be a defined period of time, if you rely on this ground, before which you can re-let your property. So just bear that in mind as family circumstances change. The other thing to bear in mind is that it will now be an offence to serve notice on a tenant before 6 months from the start of a new tenancy. So let's say a tenant moves in on the 1st of August, you would not be able to serve notice until 6 months after that date. And if you do serve notice before then, it will become an offence. Whereas at the moment, it's not an offence to serve notice incorrectly. So, for example, if you currently serve a Section 21 or Section 8 notice incorrectly or inappropriately, not in accordance with the current law, then it's just simply not valid in the court. It's not an offence in of itself. It just isn't worth the paper it's written on and won't stand up in court. So this is quite different, that it will be an offence if you serve notice incorrectly within that 6 month period from the start of a new tenancy. Tenant notice periods are changing under the bill. Currently, under current legislation, when the fixed term of a contract comes to an end, the tenant is free to leave. So let's say you've agreed a 6 month AST with somebody. When that 6 months is up, if the tenant wants to move on, they can simply hand the keys back and walk away. They don't technically have to give you any notice because the contract has simply come to an end. Once it goes to a rolling periodic under current legislation, then the tenant will need to give you a month's notice, essentially the period of the rent that they are paying. Under this bill, all tenants will need to give 2 months notice to leave, regardless of the rent payment cycle. So the 2 months notice will become standard. Now, the tenant doesn't have any restrictions on this, so they could move into your property on Monday morning at 9 AM and later that same day they could give you 2 months notice to leave. So they are within the bill, the tenants have no minimum requirement to stay in your property. I think this is potentially a risk in the HMO market. We get quite a lot of people approaching us for very, very short-term rental, anything from 3 months down to a week or two. And it's not, HMOs are not serviced accommodation, but tenants don't really understand, or tenants or people looking for accommodation short-term don't really understand the difference in legislation. We'll have to wait and see. My concern is there is a potential risk here that tenants who understand this rule will take advantage, and we'll see quite a bit more churn in HMOs where people don't want to stay very long. Under the bill, there is a provision that says that you cannot bind the tenant to give any other means of giving notice or any other period of notice. It specifically says this will have no effect under the law. The final point is that the tenant may withdraw their notice before it takes effect. Now obviously the landlord has to agree in writing, but interestingly here that this is now permitted, that the tenant can withdraw their notice. Currently, if a tenant serves notice and you line up a new tenant to replace them, and you've gone through the whole process of advertising, vetting, agreeing a move-in date, and the tenant says, oh, actually no, I don't want to move after all, then there is a piece of legislation which says that their rent can double if they stay in the property, because obviously you've been through all that time and effort and you've got somebody waiting to move in. So interestingly, under this bill, there is the option for the tenant to withdraw their notice within that 2-month notice period. There is a lot of information in the bill about the potential for a landlord redress scheme. Now, redress schemes already exist in the property industry. So we have the PRS, the Property Redress Scheme, and the TPO, the Property Ombudsman. These are 2 government approved organisations that all letting agents must be a member of. So currently, if you're a private landlord and you are self-managing, you do not need to be a member of one of these redress schemes. It's purely for letting agents only. What the bill puts forward is a redress scheme for all private landlords. So this suggests, regardless of whether you use a letting agent or not, you as that property owner need to be part of a redress scheme. Now there are items in the bill that suggest that you might not be able to market your property, so you can't advertise your property to rent unless you are a member of the redress scheme. Now there's a lot of ambiguity in this area, and the bill sets out it might look like this or it might look like this. So for example, it says the scheme may be voluntary, the scheme may be mandatory. There's lots of different things in here that are yet to be firmed up, and we need to keep an eye on what this is going to look like. It does set out though that whether the scheme is voluntary or not, there will be financial penalties for breaches. Now in my view, what I think is going to happen is that everybody will be required under law as a private landlord to be a member of the redress scheme. There will be a charge for this. I would say potentially, in my view, if I was putting this together, I would put a sliding scale together. So the more properties you have, the higher the annual fee, and I would suggest it's going to be an annual fee that you need to pay, and you'll get like a unique identifier membership number, and that membership number will have to be provided. For example, if you're going to a letting agent or you're marketing your property on various different portals in your own name. However, this is an area yet to be firmed up, so we'll see what happens and what information develops. Following on from that, there is also a proposal to create a landlord database. This will be a public domain database for anybody who is or intends to be residential landlords. Again, here there's a lot of ambiguity, and further provisions need to be determined by future legislation. The bill talks about fees may apply. In my view, fees definitely will apply. Again, I think there will be an annual subscription fee that you have to pay to be on the database, and it will be a requirement for you to be on the database. The database will hold information about you, about your property, and it will hold, for example, gas safety certificates, EICRs, EPCs, all the regulatory documents that need to be provided to tenants currently when they're on a viewing or looking to apply or move into a property. And all of this information will be free for tenants to view, and councils and other interested parties, but you as a landlord will need to pay to be on this database. It's going to also, I guess, take into account the rogue landlord database. It talks about banning orders or other offences will be visible on here. So I guess that would subsume the existing rogue landlord database. And again, here there will be financial penalties for non-compliance. In line with other financial penalties in the private rented sector, these range from £5,000 to £30,000, depending on the breach and the severity. property and various other different aspects which will be firmed up as time goes on. Now, interestingly, at the beginning, I did mention the white paper that was published last summer, and in the white paper there were 12 different points. I did do a video on the white paper last year, which will be in the archive somewhere, so if you want to go back and have a look at that, you're more than welcome to check that out. I've gone back and I've just had a look through the key points that were set out in the white paper compared to what's currently in the bill that has just had its first reading in Parliament, and there are a couple of things missing in the current bill in its current form. Now, what that might mean is that these things might be brought in as amendments, for example, during the committee stages and the evidence stages as the bill progresses, or more likely they will be dealt with under separate legislation at another point in the future. So the first thing was about applying the decent home standard to the private rented sector. This is already a definition, and the white paper set out that it would become a legal requirement to apply this to the private rented sector. I've had a look through the Renters Reform Bill and I can't see any reference to the decent home standard in the bill in its current form. So that's something that might be coming in the pipeline a little bit later on. The white paper also talked about disallowing blanket bans on renting to people claiming benefits or families with children. There are some landlords who won't accept children. Again, there's additional wear and tear to your property, more likely for damage, potentially more likely to upset neighbours depending on the area, and also some landlords have a blanket ban on people claiming benefits. This was proposed in the white paper. Again, there's no specific mention of that in the current bill as it stands today. One other aspect that the white paper talked about was court reform, and this is definitely needed, particularly with the abolition of Section 21 notices and the changes to Section 8 grounds. For many years now, there has been a backlog in the court system with enforcing Section 21 and Section 8 notices. This was exacerbated hugely during the COVID pandemic, when the government actually closed the courts for quite a prolonged period of time. And then when the courts were reopened, they banned the issuing of notices over the winter and Christmas period. So effectively, people were unable to regain possession of their property from unsuitable tenants for quite a prolonged period of time. That, together with other issues in the court sector, has meant huge backlogs in people waiting to regain possession of their property where people are not paying rent or exhibiting antisocial behaviour and disturbing the community. The white paper did talk about court reform, about making things slicker, making more focus on housing cases and digitising a lot of the process. Again, none of that is mentioned in the reform bill, and again, for me, that is a concern in terms of the Section 8 grounds are being changed and reformed, but actually they're not going to be much value to landlords if they can't then enforce them through the court structure. So we'll have to wait and see what happens on that as well. The white paper talked about strengthening council enforcement powers. Not sure where this is going. The local councils do have a lot of enforcement powers already. In my view, there is sufficient legislation in place for local councils to take action against rogue landlords. However, again, in my experience, what I found is that local councils have different approaches. Some have more resources than others in terms of money and people to actually enforce the rules that are currently in place. So for me, it's not about legislation, it's about resources and focus of the local councils on rogue landlords. And the final point that was mentioned in the white paper was tenants having transferable deposits, or a passport scheme they talked about. What they're suggesting here is that when a tenant applies for a property and pays a deposit, when they then want to move or have to move because they've been asked to leave, there is a delay in getting their deposit back. So the DPS who we're with have a 7-day, up to a 7-day turnaround time. We try and give people's deposits back pretty much immediately on checkout. However, potentially then, if there is a dispute over cleaning or damage or unpaid rent and you want to retain some of the deposit, there isn't currently a mechanism by which the tenant can transfer that deposit to a new property. And that is the sticking point, I guess, that nobody has really got over yet. So in conclusion, there are still quite a few aspects of the white paper that are not currently in the bill. So as the bill goes through Parliament, I'm sure some of these topics may come up in the discussions and the evidence and the select committees and all the various different debates that are going to go on. So we'll just have to wait and see. Things are not going to be progressing until much later in the year now. The second reading needs to happen in the Commons before people can get into the nitty-gritty of the debate and make any suggested amendments to the bill as it currently stands. But as there are significant changes, I can keep you posted.